Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. My name is Pete Steinmeier. I'm the managing shareholder of Epstein, Becker & Green's Chicago office, co-chair of EBG's Trade Secrets and Non-Compete Subpractice, and a self-proclaimed non-compete nerd. 2024 was a year like none other in this space, with the FTC's proposed non-compete ban, the NLRB General Counsel memoranda holding that non-competes violate the NLRA, and non-compete bans proposed in a multitude of states across the country. At times, the changes were coming so fast and furious that I just wanted to shout to everyone, everybody, just stop. I've got work to do, and I can't keep spending all of my time writing alerts about new or proposed changes. But then, almost as quickly as it was issued, the FTC's proposed non-compete ban was enjoined by two separate federal district courts. Thereafter, the new administration came in and promptly revoked the NLRB General Counsel's General Counsel memoranda holding that non-compete agreements violate the NLRA. And so suddenly, things became very quiet at the federal level. However, at the state level, if anything, there's more legislative action than ever before in this space, perhaps inspired, at least in part, by the unsuccessful non-compete bans at the federal level. As a result, employers are once again scratching their heads and struggling to stay on top of the new and proposed laws, while asking what they can and should be doing to protect their trade secrets, confidential information, and customer relationships. These are the topics that we will be discussing today with an all-star panel of fellow non-compete nerds. From our Newark, New Jersey office, we have one of the regular co-hosts of the pod, Dan Levy. Dan, welcome.
Thanks, Pete. It is great to be back. Looking forward to it. And I echo your thoughts when you say that you just wanted to shout in 2024 to stop. I feel that way in 2025, except I feel like doing it in multiple jurisdictions as opposed to one area directed at the FTC.
Well, we're delighted to have you on board. And from the city that never sleeps, New York City, we have David Clark. David, welcome.
Thanks, Pete. It's a pleasure to be here. And thank you for classifying me and all of us as non-compete nerds. It's a title I wear proudly.
As do I. And last, but certainly not least, from the Chicago office and literally sitting about 10 feet away from me, we have a rising star of the field, Carolyn Bocek. Carolyn, welcome to the pod.
Thank you so much. Thanks for having me.
David, would you mind kicking off the program today by summarizing the new laws actually enacted in this space so far in 2025?
Sure thing, Pete. There are 4 new state laws regarding non-competes and restrictive covenants that I think our listeners should be aware of. These laws have either been enacted or will be coming online as new laws later this year. So let's jump right in. First is Arkansas. Arkansas has passed a new law that affects healthcare workers. It's called an Act to clarify that a covenant not to compete agreement is unenforceable for certain licensed medical professionals. It was signed into law in March by Governor Sarah Huckabee and is to take effect around mid-July of this year. This new law will prohibit non-compete agreements that restrict the right of a physician to practice within the physician's scope of practice. And the term physician is broadly defined to include individuals licensed under the Arkansas Medical Practice Act, as well as those licensed to practice in osteopathy. I think I pronounced that correctly, under Arkansas law. Once in effect, the law will render such non-competes void and unenforceable, although it's unclear as yet whether the law is retroactive or not. It may just affect new non-competes for physicians, but that remains to be seen. And the law does not apply to non-solicits or confidentiality or non-disclosure agreements. That's the new law in Arkansas. Again, just affecting healthcare workers. Let's turn to Virginia. There's a new law enacted already there that affects low-wage workers. Now, this bill expanded Virginia's existing non-compete law to provide broader protections to workers. Since 2020, Virginia has prohibited employers from entering into or enforcing or threatening to enforce non-compete agreements against so-called low-wage employees. And that's defined as those earning less than a threshold amount, which is currently around $76,000 annually. So under the amended law, the definition of low-wage employee will also include any worker classified as non-exempt under the Fair Labor Standards Act. And that is those workers who are entitled to overtime compensation, regardless of income level. In Virginia, low-wage workers also include students, interns, trainees, independent contractors, but it does not include employees whose compensation is derived in dominant part by commissions or incentives or bonuses. So the law prohibits employers from applying non-compete agreements to these low-wage employees. And importantly, for employers, it provides for significant enforcement mechanisms, including injunctive relief, damages, attorney's fees, and civil penalties of up to $10,000 per violation. So this is not something that employers want to run up against.
So, David, I have a question about the Virginia law and how it will likely play out. What if a Virginia employer essentially, mischaracterizes one of its employees as an exempt employee, but in reality, they are a non-exempt employee?
If the employee resists the non-compete and the employer tries to enforce it, that may become a question of fact for a court to determine. And I would advise employers to be conservative in that regard and be careful because the penalties are stiff for violating the statute.
So it sounds like we're kind of getting into an area where employers not only have to be concerned about their non-compete agreements and possibly changing them in Virginia, but also taking a look at whether they're properly classifying their employees as exempt or non-exempt.
Yes, absolutely. Yep, I agree with that. So I'll turn to the next state that has a new law coming into effect, and that's Wyoming. And this is a law of general applicability. The Arkansas law I spoke about related to healthcare workers, the Virginia law I spoke about related to low-wage earners, but this Wyoming law is of general application, and it goes into effect July 1st, 2025. And it starts off by saying that it voids any covenant not to compete that restricts the right of any person to receive compensation for performance of skilled or unskilled labor. So at first blush, the law appears to broadly void non-competes entered into on or after July 1st. But there are broad exceptions in this new statute, including to the extent the covenant provides for the protection of trade secrets, it may be enforceable. And the statute also exempts non-competes for executive and management personnel, or officers and employees who constitute professional staff to executive or management personnel. So those are pretty big exceptions to the statute. It's still going to be important for employers in Wyoming to be aware of this statute and be careful about who they're asking in terms of their employees to sign non-compete agreements. The Wyoming statute is also not retroactive.
David, I have a question on this one. Because the exceptions are so broad, are you thinking that this might be a case where the exceptions may swallow the rule?
I think to some extent, yes. For certain employees who are clearly not executive or management personnel or professional staff who work with executive or management personnel, yes, the law will apply to render any non-competes with those folks unenforceable. But again, the exceptions are so broad that I do think in many cases, the exceptions will swallow the rule.
So, David, just to kind of follow up on Caroline's question, there's generally 4 states that fully prohibit non-competes. Those are California, North Dakota, Oklahoma, and relatively recently, Minnesota. Would you say that Wyoming, as of July 1, will fall into those categories of states, or would it be similar to a state like Colorado that, in addition to some other procedural requirements in Colorado, like notice and a minimum salary, Colorado's non-compete act applies really only to protect trade secrets?
That's a good question, Dan. And I think Wyoming falls into the Colorado camp rather than the total ban camp of those other four states. It's not a total ban, even though at first blush it might appear to be. The exceptions really are quite broad and will allow for non-competes in many types of situations with many types of employees.
I absolutely agree with you. And when I first read kind of that Wyoming was passing this bill, I thought it was falling in line with California and Minnesota and the other states. But in reading it, it does not seem that way.
I had the exact same reaction. I saw a headline that said, Wyoming bans non-competes. And so I pulled the statute and read it. And as I read it, I basically reached the same conclusion that Carolyn reached, which is that the exceptions almost swallow the law. So I would not put it into the same category, although at first blush, that was my reaction. So sorry for sending you off on a tangent, David. I know you're marching through all of the states. Continue on.
No problem. One final note on the Wyoming statute. The act that enacts that new law contains a separate provision that voids any non-compete agreement between physicians, that restricts a physician's ability to practice medicine. So that's another targeted provision focusing on healthcare workers, certain healthcare workers. And just to note, I'm not going to go into them because of time constraints, but some other states have enacted laws this year restricting non-competes on physicians or healthcare workers. And those are Louisiana, Maryland, and Colorado. The last state I wanted to talk about today is Kansas. Kansas's new statute is actually pro-employer rather than pro-employee, which is how I would classify the other state laws that we've been discussing. The Kansas law does not place requirements or restrictions on the use of non-competes, but it focuses instead on non-solicit provisions. So it's likely that non-competes will continue to be enforced consistent with Kansas state law. And Kansas has long-standing common law principles of freedom to contract and wide discretion for the parties to enter into an employment agreements. And those principles will in all likelihood continue to extend to non-competes in employment contracts in Kansas. But as I mentioned, the Kansas law does place restrictions on the use of customer and employee non-solicit provisions. First, it requires both kinds of provisions to be in writing. And with respect to customer non-solicits, the new law says that customer non-solicits will be conclusively presumed to be enforceable and not a restraint of trade, provided that it's limited to material contact customers and the covenant is between an employer and an employee and does not continue for more than 2 years following the end of the employee's employment. Similarly, employee non-solicits under this new Kansas law shall conclusively be presumed to be enforceable and not a restraint of trade if they're between an employer and an employee, and the covenant seeks on the part of the employer to protect the employer's confidential or trade secret business information or customer or supplier relationships, goodwill or loyalty, and is not for a period longer than 2 years. Thus, for customer and employee non-solicitation provisions, 2 years is the outer limit under this new Kansas law.
Well, thanks, David, for that update. That is an awful lot to keep track of. And for our listeners, I want to let you all know that David, Dan, and Carolyn are the 3 editors of EBG's 50-state non-compete survey, which also has a healthcare supplement. And we are in the process of doing an updated version of that. And that update will be coming out sometime in the near future. But in the meantime, Dan is going to take us through the scores of proposed non-compete reforms in this space. Dan, take it away.
Thanks, Pete. At last check, there are dozens of non-compete bills pending across the nation in various legislatures. While it remains unclear which of these bills will be enacted into law, the legislative trend is very clear. At least 12 states have pending bills aimed at restricting the use of non-competes. And I'd like to start with some of the major ones. I'll kick it off with the state of New York, not only because I think it has legislation that I think will pass, but also because it is the home of the most storied franchise in both baseball and all of professional sports, not being Juan Soto and the Mets, but the New York Yankees. So in New York, on February 10th, 2025, New York Senator Sean Ryan introduced Senate Bill 4641 that, if passed, would prohibit non-competes with quote unquote covered individuals, with only limited exceptions for quote highly compensated individuals who make at least $500,000 per year, or non-competes entered into as part of a sale of a business. This bill is particularly interesting because the New York legislature had previously introduced a full non-compete ban without exceptions. And that bill came very close to being enacted into law, but Governor Hochul vetoed that bill in December 2023, stating that she'd be open to such a bill and a ban on non-competes if there were exceptions for highly compensated individuals and in connection with the sale of a business. So this bill addresses those two issues sought when the governor vetoed the last bill in 2023. And there has been some recent activity on this bill. In May 2025, the bill was sent to the Judiciary Committee, and it was released from committee and back to the Senate about a week and a half ago. This bill is currently moving forward, and I do think that it will gain some traction in New York. It's hard to tell when it will really move forward, but I am anticipating that it will. Moving next to Illinois, last month, a proposed complete ban passed a state house committee, although this bill is not expected to go any further this year. There appears to be a lack of legislative enthusiasm given the legislature unanimously passed non-compete reform legislation that went into effect on January 1, 2022. Also, the Illinois Chamber of Commerce and other business groups strongly opposed the proposed ban. Pete, as you were in Chicago and have been much closer to this, I'd like to hear your thoughts on what may happen in Illinois.
Yeah, thanks, Dan. I was very involved in the 22 non-compete reform legislation on behalf of the Illinois Chamber, and I was again involved this year in connection with the proposed legislation. And I think you never know, but I think the legislation for this year is not going to go any further. And the reason why is that Illinois just enacted comprehensive reform legislation as of January 1, 2022. And they not merely enacted it, it was enacted unanimously in both the state house and the state senate. And I just think that the feeling was, hey, we just enacted this comprehensive reform a few years ago. Let's give it some more time, which isn't to say that there won't be efforts in future years to either modify the legislation or perhaps even to try and ban non-competes again in Illinois. But I think for at least this year and the foreseeable future, I don't really see that happening. There just doesn't seem to be any political oomph for it, given the unanimously passed reform legislation that we just had.
Thanks, Pete. Do you think that there was any movement there as a result of what was happening in the FTC?
I think there's been movement all across the country. I mean, I think everybody, whether you're in the legislature, whether you're a lawyer, whether you're just a ordinary working person in the country, you're aware of the proposed non-compete ban. They were top of mind last year, and it's just got people talking about them and whether they're a good thing, whether a bad thing, whether they're fair, whether they're not fair. And I think people have dueling notions about them. On the one hand, people instinctively feel that you ought to be free to go work wherever you want to go work. But then on the other hand, the more you think about it and you look for specific details and you think about the specific scenarios where somebody could be a high-level executive or senior salesperson or scientist or engineer, and the thought of them just crossing the street and going to a direct competitor the very next day, once you start to think about that, people go, maybe non-competes aren't so bad after all. And I think that that's why we're seeing legislative compromise worked out in the laboratories of democracy, and different states are coming up with different solutions. There hasn't been a movement at the federal level to have any kind of federal regulation apart from the proposed flat out ban. And that could be something that happens in future years. Although, given everything that's going on in DC today, I don't think that that's high on anyone's agenda.
Great, thanks. And I think those are all very good points. And I think it leads into part of this discussion, which is that there are at least 6 other states that have pending bills that, if passed as is, would lead to a complete ban on the use of non-competes. But I do think that many of these, as they go through the legislative process, there will be negotiation and some compromise on some of them, and we'll see where they lead. So first is Michigan. House Bill 4040 would prohibit entering, enforcing, or representing the existence of a non-compete with any worker, subject to limited exception for the sale of a business. The bill was introduced at the end of January 2025 and was referred to the Committee on Economic Competitiveness, and no further action has taken place as of yet. Next is Washington State. Washington has passed several laws affecting non-competes and non-solicits over the past several years, and the latest bill, HB 1155, would further broaden the definition of a non-compete covenant to void all employer-employee non-competes and would even apply retroactively. If passed, the bill would require employers to inform current and former employees or independent contractors that their non-competes are no longer enforceable. For employers with employees in California, this notice requirement would be similar to what California had required a couple of years ago. The Washington bill has been in the Rules Committee since mid-March 2025. That will be an interesting one to watch to see if Washington is going to essentially follow California in not only banning non-competes, but requiring notice to go out to all employees and former employees to inform them of such. Next is Ohio, which introduced Senate Bill SB 11 in February of 2025, and that bill would prohibit non-competes with both workers and prospective workers. The bill has been assigned to the Judiciary Committee since January 29, 2025, without further action. Another bill introduced in early 2025 was in Tennessee, where they introduced companion bills, Senate Bill 995 and House Bill 1034, which, if passed, would prohibit non-competes in Tennessee with the limited exception of the purchase of a physician's practice. Both bills have been assigned to committee and have been there since March of 2025. Next is Arizona. House Bill 2589 would prohibit employers from requiring a non-compete clause, which is defined in the bill as a clause in an employment contract with an employee that prohibits the employee from working in a specific geographic area for a specific period of time after leaving employment. That bill is also currently pending in committee. It's the House Commerce Committee. And finally, I would like to talk about Texas, which is the 6th state that has introduced a bill this year to ban non-competes. That is Texas Bill HB 4067, and it follows very closely the proposed FTC non-compete rule. If passed, the bill would amend Texas's Business and Commerce Code to prohibit non-competes against all workers and would prohibit non-competes with quote-unquote senior executives after September 1, 2025. That bill was referred to subcommittee in late March. And it's interesting because, Texas would essentially follow what the FTC ban looked to do. I don't think that bill will gain much traction in Texas, which is a traditionally employer-friendly state. I did want to stop here and discuss some other pending bills in other jurisdictions, but wanted to give a plug for our trade secret and employee mobility blog, where we have discussed all of these bills in more detail and will provide updates on them to the extent further action is taken.
Dan, I have a question. There's a lot of proposed bills that you've talked about here, but going back to Pete's point earlier, how much of this do you think is signaling by legislators who have no expectation that they'll actually pass versus earnest attempts to impose new legislation? And how can our listeners tell the difference?
I think that some of this is certainly a political step after certain legislatures felt like their constituents wanted the FTC non-compete rule to pass, and it was a reaction to that to set forth proposed legislation. I think that for some of them, they are aware that they're likely will not pass, and I think Texas is one example. But I also think that the goal is to try to introduce this legislation to get a discussion moving forward and lead to compromise where they can pass legislation that might require some restrictions, such as Illinois has with providing notice to the employee or restricting it based on a minimum salary threshold and get the legislation through that way. David or Peter, do you have other thoughts on that?
I was just going to add that I think non-competes are sort of a strange beast politically because on the one hand, there are 4 states, as you mentioned, that ban them. California and Minnesota, 2 of the bluest of the blue, and North Dakota and Oklahoma, perhaps the reddest of the red. What else do those 4 states happen to agree on? Attitudes towards non-competes don't conveniently follow the traditional political perceptions of given states. So it'll be interesting to see how this all plays out. But my prediction, looking down the road 5 years, is that we will continue to see non-compete reform legislation across the country. I think we'll see more minimum salary thresholds. I think we'll see due process protections like review periods, mandatory advice to seek counsel before signing, things like that. That's what I think is going to be most common. I think we may see some additional non-compete bans. I don't foresee non-solicit bans, but Carolyn's going to be talking to us in a couple of minutes about what should employers be doing in light of all of this. But as I look into my political crystal ball, that's what I predict. David, how about you? You have a different political prediction than mine?
No, I agree with all that you just said, Pete, but I think the only thing I'll add is that, yeah, it's the rare bill that gets enacted into law. That there are dozens of examples of state legislation that's pending now across the country, but it'll just be probably a handful that will actually be enacted into law.
Yep, that's a good point. And, we certainly continue to follow them because it's important for employers to know, especially those with employees in all different states, that, they comply with these rules as they're passed. It's a difficult undertaking for employers who have employees throughout the nation, especially for legislation that's passed that exempts choice or prohibits choice of law clauses in their agreements. And, I think that might be a whole discussion for another day and what employers can do to address that. But I did want to discuss some of the other pending bills in a few other states that have essentially included procedural requirements of restricting the use of non-competes for employees who do not meet a specified salary threshold. The use of minimum salary thresholds for non-competes have been implemented by several other states over the past few years. Those currently include Colorado, the District of Columbia, Illinois, Maine, Maryland, New Hampshire, Oregon, Rhode Island, Virginia, and Washington State. In March of this year, North Carolina introduced HB 269, which, if passed, would be known as the Workforce Freedom and Protection Act. And if that bill is enacted into law, it would ban non-competes for North Carolina employees earning less than $75,000 per year. That bill was referred to the Committee on Commerce and Economic Development, which is where it has remained since March. Next is Vermont, in which the Vermont Senate introduced Bill 205 to the General Assembly of the Senate. If passed, the bill would void all non-competes with employees making less than $100,000 gross annual wages. The bill would exempt confidentiality and non-solicit provisions with specific and reasonable geographic and temporal scope. That's been referred to the Committee on Commerce and Economic Development as well, and that's where it remains currently. And the third state is Kentucky, which introduced a bill aimed at limiting non-competes based on a minimum salary threshold. There, the Kentucky legislature introduced House Bill 690 in February 2025 that, if passed, would prohibit employers from entering into, threatening, or enforcing non-competes with any covered employee. And covered employee is defined as an employee earning less than $2,000 per week. The bill was sent to the House Economic Development and Workforce Investment Committee, where it has remained. Now, as we have reported since the introduction and defeat of the FTC non-compete bill, the states are likely to continue to pass and introduce legislation aimed at prohibiting or restricting employer non-competes. But I do want to raise a bill introduced in Florida that, similar to the bill that Kansas enacted that you spoke about, David, that is employer friendly. And that's House Bill 1219, known as the Florida Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth Act, which is a mouthful and is known as the Choice Act. If enacted, this bill would expand upon Florida's already existing law that allows non-competes and would provide a framework for two other enforceable non-competes and garden leave provisions, with the apparent intention to strengthen rather than weaken restrictive covenants in the state of Florida. The Act sets out specific requirements for non-competes and garden leave provisions that, if met, would render those restrictive covenants not a restraint of trade under Florida law. On April 23rd of 2025, the House passed that bill. The next day, the Florida Senate voted 28-9 in favor of it. And the next step would be for the governor's signature. And if it is signed into law, it would be scheduled to go into effect on July 1, 2025, but that date certainly may change. And we are keeping a close eye on that Florida bill.
Thanks, Dan. That is quite a lot to track. I personally am delighted that you three are the editors of EBG's blog, so you three are the ones charged with staying on top of all of these laws. And as you said, Dan, we cover them all on our blog, so subscribe to our blog if you don't already, and you can stay up on top of all of these laws. Carolyn, given all of this, what are some of the options that employers still have to protect their trade secrets, confidential information, and customer relationships, and what can and should they be doing now?
Thanks, Pete. That's a great question. With the amount of legislation that's going on, employers really need to keep a firm grasp on what the current laws are and to stay up to date with the shifting best practices. That's easier said than done for sure. As Dan discussed earlier, employers are increasingly finding themselves limited by local and state legislation when entering into and enforcing non-competes. But that doesn't mean that they're out of luck completely. They can often use other types of restrictive covenants to achieve the same end. As the famous Mick Jagger would say, you can't always get what you want, but if you try, sometimes you just might find you can get what you need. And that's a good rule of thumb when it comes to restrictive covenants as well.
Carolyn, I have to add, I'm just delighted that people are still quoting Mick Jagger.
Of course, the icon. Figuring out what kind of information that you need to protect and who you need to protect it from is half the battle. And that information is of no use if you don't know what your available options in protecting it are. So we're going to go through a few options that employers have. First, when we think of restrictive covenants, we typically think of dividing them into two categories. The first being agreements that are effective during employment, and the big one there is a non-disclosure agreement or an NDA. NDAs are critical for anyone who has access to trade secrets, whether that's customer information, product formulas, or other sensitive information. But do take note that to establish trade secret status, employers need to be able to show that they take reasonable measures under the circumstances to protect that information. Otherwise, they might not be considered truly trade secrets. But NDAs aren't a panacea. There are differences in various state laws. For instance, in our neighbor to the north, Wisconsin, even NDAs have to be limited in temporal scope. And there's some other requirements in other jurisdictions. So they aren't a one-size-fits-all type of thing. And also there are changes under the NLRA and interpretations of the NLRA by the NLRB and various whistleblower laws that can impact what is permissible to protect with an NDA. So again, it's not a set it and forget it type of protection, but it is an important tool in employers' arsenals. The second category being agreements that go into effect after the employment relationship ends. Those are post-employment restrictions, the critical one that we've been talking about are non-competes. Non-competes are generally only ever post-employment because competing with an employer during employment is generally prohibited, if not at least frowned upon, by common law and other types of business torts. With the decline of the non-compete, we are seeing more use of non-solicitation agreements. And non-solicits prohibit former employees from recruiting clients of their former employer, generally for a period of time after their employment ended. Typically, these non-solicits are enforceable only as to clients of the former employer with whom the former employee had contact or confidential information about at their former employer, which kind of makes sense. It wouldn't cover every one of the former employer's clients, only those that the employee had access to. And I can't emphasize this enough, non-solicits are the future. Courts are far more likely to enforce them than a true non-compete, since the latter may have the effect of limiting the employee's ability to work and make a living categorically in a given region. They work really well virtually for every employer with employees in sales or in customer-facing roles. So it's a really important tool and kind of what we're looking forward to in this space moving forward. Similarly, employers can use non-recruitment provisions. There's a slight distinction here that's important to note. There are no poach agreements where two employers agree not to poach each other's employees. And then there are no recruit agreements where employees agree not to solicit their former coworkers. This distinction is important because no poach agreements have been considered problematic under antitrust laws and can implicate some liability under those laws. And they can only be used in very limited short-term situations, whereas no recruit agreements are more aligned with non-solicitation agreements and are more commonly enforced than no poach agreements. They're also more commonly enforced than traditional non-competes and even some non-solicits. The theory behind them is that employers have a legitimate business interest in the stability of their workforce, and that can be protected by contract law. And I know I said earlier that restrictive covenants are typically split between those that are capable of being imposed only after employment ends and those that are capable of being imposed during employment. There are some alternatives to non-competes which kind of blur that line, and we're seeing those that are emerging as a result of the recent legislative activity restricting the use of non-competes. And the big one there is the use of true garden leave. With true garden leave, it's basically an extended paid notice period before the termination of the employment relationship. So the employee gives notice that they're going to leave, and they're still on the payroll, they're still an employee, and they're still getting paid for a period of time. These are more common in the United Kingdom than they are in the United States. They're really only seen here in the financial services industry. Some of the business consulting world is also using them, but typically it's financial services. And the idea is that the employee remains employed for all intents and purposes and is paid and given typical benefits and therefore is subject to the fiduciary duty of loyalty during that notice period. It's great for the employees because they generally aren't assigned any job responsibilities during this period, so they can do whatever they want. That's the origin of the term garden leave. It means you can go tend your garden or do whatever. They're expensive for employers because employers incur all the cost of employment, but they get none of the benefit of the talent because typically employers don't want to have these employees have any more access to their information once they know that they're leaving. So they don't get the benefit of the talent, but they're still paying. But they're almost universally upheld by courts. Personally, I love these. Who wouldn't want to get paid to do nothing for a few months? Out of curiosity, Pete and David and Dan, if you had a year of paid garden leave, what would you do with it?
Well, this is Pete. Speaking for myself, I would definitely move out to Hawaii and learn how to surf.
And this is David. I have a long list of things to do around the house that I'll probably never get to. But if I was getting paid to sit around the house, yeah, I guess I would make the effort to do those tasks.
And I don't know where I would go, maybe South Carolina, but if I had a year off, I would like to play 365, if not more, rounds of golf.
Very nice. Very nice. I'd probably dig into my to be read pile, but very good.
I do have a question about the garden leaves because I've had conversations with clients who have asked me about setting up non-competes, and we do have a discussion of garden leaves. But one question I often get from a client is, well, I don't want to tie myself in to having to pay a particular employee for them to sit out if it turns out that we don't really want to enforce the non-compete. Can you set a garden leave agreement up where the employer has the option to enforce the garden leave provision and pay, or can it voluntarily and unilaterally waive that requirement?
You can do that, but you just need to be very, very specific in the contract that you are reserving the right to do so. What you cannot do is enter into a true garden leave clause, and then when it comes time to actually abide by the garden leave clause, you cannot at that point say, it's off, just kidding, we're not actually going to pay you, we don't want to pay you. You can't do that, but you can reserve a discretionary option to shorten the garden leave period, and that is a common provision.
Yeah, I think one of the complications with that question is in the United States, we don't have use typically of these. So there isn't a ton of case law out there about how they're going to be treated. And so in the United States, it's really hard to answer based on the lack of case law. But employers who do utilize true garden leaves should be very careful to make sure that these contracts are carefully worded, unambiguous, and that are as ironclad as possible about the expectations.
Yes, and I generally agree. I think as long as you are providing the carefully worded statement in the agreement that the employer has the ability to waive the garden leave and not pay, it can be done, but it's, you can't, as you said, Mick Jagger would say, you can't get everything you want.
Yeah, and that leads me to there's another option that I call fake garden leave. It's essentially a paid non-compete post-employment. So instead of staying on as an employee, like true garden leave, the employment relationship is severed. And then the non-compete period is a paid period of unemployment, where the employee agrees to stay out of the competitive arena. They're a little bit more controversial than true garden leave. Under the FTC's non-compete ban, had it gone into effect, they would be prohibited because it would be considered a non-compete, not an extension of the employment relationship. But many jurisdictions are permitting them because they don't box former employees out of the market without offering them a means to live, which is primarily the concern for a lot of jurisdictions in entering non-competes. And then finally, we have our last option that we're going to talk about is forfeiture for competition agreements, which are sometimes called golden handcuffs. These agreements offer departing employees a generous separation package that is contingent on remaining in a non-competitive posture. Courts generally look on them favorably, but that's not universal. For instance, in Illinois, these types of agreements are still considered traditional non-competes and subject to the statutory requirements for non-competes. Forfeiture agreements, they can be great, but they can also be costly because you have to monitor what your former employees are doing, and then you have to incur the cost of enforcing them. So they sound good, but they can be quite messy. As with any of these, employers should be very careful that the terms of forfeiture provision in particular are set out very clearly in any kind of separation package and exactly what terms are going to trigger forfeiture and what forfeiture looks like, timelines for repayment, those types of things. All of that really needs to be spelled out. Otherwise, it can get extraordinarily messy and can jeopardize the enforceability of the agreement. So in all, we're seeing a huge departure from employers being able to rely exclusively on non-competes. So they're having to look to other types of restrictive covenants. But what type of restrictive covenant is right for a given employer depends on a huge number of factors. So the employer's industry, the size, their geographic reach, their risk tolerance, internal controls that are already in place for protecting confidential information. Those are just a few of them. But it's exciting too, because employers can get creative with what needs they really need to address.
Words of wisdom, Carolyn. Thank you. And thanks to each of you for joining the pod today.
Great. Thanks for having us, Pete. It's been great as usual.
Agreed. Thanks very much, Pete, for having us on.
Thank you so much, Pete. It's been a pleasure.
A special thank you to our listeners. If you would like to subscribe to the Spilling Secrets podcast, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes Spilling Secrets podcast series. In fact, if you'd like to subscribe to any of EBG's various alerts, insights, etc., or other podcasts, you can do so from the same webpage. So I encourage our listeners to go there. Thanks again, everyone, for joining. Until our next episode, this is Pete Steinmeier signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.